on DC 23-17198, Husak versus Baylor Scott and White Health. Counsel, make your appearances.
Good morning, Your Honor. Christian Havens on behalf of plaintiff Katie Husak.
Good morning, Your Honor. Alicia Voltmer here on behalf of defendants Baylor Scott and White Health and Health Texas Provider Network.
Okay. Is that everyone? All right, let's get started. Ms. Voltner, is this your motion?
Well, Your Honor, we did set our motion for summary judgment for hearing, but the court also set plaintiff's motion to continue the summary judgment hearing. So if the court would let us know what it would like to hear first, we can certainly accommodate.
We'll start with theirs. That's a good idea. Mr. Havens, you may proceed.
Yes, thanks, Judge. Do you mind if I share my screen real quick?
You may.
Can you see my screen, Judge?
I can.
Yes, so again, we're here on plaintiff's motion for continuance on defendant's second motion for summary judgment. And I just wanted to provide the court with a brief background of this case prior to going into our arguments. So plaintiff filed this suit in October of 2023. We had an initial summary judgment back in late November. The hearing was held in January of this year. And then a few weeks later, the court entered defendants the order denying in part defendant's first motion for summary judgment. In that order, the assault claim was maintained, and so immediately after 6 days, plaintiff served defendants HTPN, Health Texas Provider Network, as well as Baylor Scott and White with plaintiff's first request for production and interrogatories. Thereafter, plaintiff designated her causation expert. And then on April 1st, defendants requested a 2-week extension to respond to the RFPs and interrogatories, and they also stated documents would be served. During this extension period, defendants asked for a 2-week extension and serve documents as well as their responses to the discovery on April 17th. Now, during this extension period, defendants filed their second motion for summary judgment. Plaintiff received their responses to discovery thereafter, and on the 17th, and it was filled with boilerplate, frivolous objections, and defendants only produced 5 pages of document production, and those being plaintiff's own pay records. So immediately thereafter, plaintiff served defendant's counsel with a discovery letter outlining how the frivolous objections were put forward and asking to confer on the discovery issues. Defendant's counsel the same day responded stating that she could not confer until May 7th on the discovery issues, which was the day after our motion for summary judgment response was due. Defendant's counsel also stated that they had not produced Dr. DeMaio's employment records, who was one of the defendants employed by HTPN Health Texas and also an agent of Baylor Scott and White. Defendant's counsel advised for the first time that there had not been a protection order entered, and so they had not produced the employment file. There had not been any mention of the employment file or a protection order prior to this day. And no mention of it in the discovery responses either. So in the day after, plaintiff requested the deposition dates of Dr. DeMaio, one of the presidents of Baylor Scott and White, Mark Valentine, and corporate reps for both defendants. And we also included a list for topics for the corporate rep depots. As the court is aware, defendants filed their second motion for summary judgment, and plaintiff has filed their request for a continuance, and pursuant to TRCP 166 AG, the court may grant a continuance based on an affidavit which has been filed in our continuance that describes the evidence sought, explains its materiality, and shows that the party requesting the continuance has used due diligence to timely obtain the evidence. So, Your Honor, the evidence sought is, first of all, full and complete responses to our discovery requests and interrogatories.
Can I ask a question here?
Yes, Judge.
So as you know, or it's my understanding, I should say, that the sexual harassment claims were previously dismissed. The federal sexual harassment claims were previously dismissed by the federal judge who initially handled this, correct?
Correct.
And I dismissed some additional claims in the summary judgment, correct?
Correct.
So the remaining claims we have are for assault, correct?
Correct. And IIED.
Intentional infliction of emotional distress, correct?
Correct, Judge.
So I'm wondering, and let me just say this, if the law was according to Judge Hoffman, no offense, Ms. Woltner, I would not have ruled the same way, or would not have wanted to have to rule the same way that the federal judge did. I thought he was probably following current case law. I don't agree with that case law, and I can't understand why this isn't sexual harassment, but you know, we all have to follow the law as it is at this point. I'm just wondering why the employment file, the correspondence, the safety manuals, the investigative reports, evidence of disciplinary action, corporate reps, why is that relevant in a assault / sexual intentional infliction of emotional distress? If it was a sexual harassment case, totally can see it, but why is it material? Maybe you're getting to that. Why is it material in this case when all we're dealing with these, unfortunately due to law, these remaining claims?
Yes, Judge, that was my very next slide.
So I will tell the room full of interns, this is very impressive. This is one of the best motion for continuance I've seen on a summary judgment. So great job in putting this together. You anticipated my question.
I appreciate it, Judge. And so, yeah, the materiality is the second element of 166 AG. And there are allegations in this case that once the assault was reported by the plaintiff, that Mark Valentine, the president of the Baylor Heart Hospital, held a come and go meeting where there were nurses and staff coming and going, and that he stated that these sorts of things just happen working in close proximities. And so our allegations, and we contend that.
And I want to make sure I'm recalling the facts of this. What exactly happened between the plaintiff and the defendant in that hospital room? I remember that there's a claim of sexual assault, but I don't remember exactly what happened. Was it
So the allegations are that plaintiff is a nurse, Dr. DeMaio is a doctor, and they were working closely within in a hospital room, and Dr. DeMaio essentially was looking over her shoulder, watching her care for a patient, and then slid his hands on her back, down her sides, and then on her buttocks. That's in essence the assault claim here. Now, courts have found that intentional torts can be within the course and scope of employment, and it's generally a fact issue. So we are just seeking some of the discovery and to depose Mark Valentine, the heart hospital president, who stated this in that meeting, and we allege that it could it goes to course and scope if he concedes that it sometimes
Ms.
happens.
Let me ask this, Ms. Waltner, is that accurate that the president of Baylor said that this type of thing happens regularly?
Your Honor, there is no evidence in this record to that. In fact, both parties have filed motions to strike the summary judgment evidence. The plaintiff says that this occurred, but she wasn't at said meeting, and someone else who she doesn't name allegedly said it occurred at this meeting. So this is something that is not even in evidence. And even if it were, though,
What meeting are you talking about? A meeting that the president
whatever meeting he's alleging occurred with Mark Valentine.
Okay.
And Judge, if I may, the reason it's not in evidence is because we haven't been able to procure the discovery. We've been met with all these discovery objections, and we wanted to get the documents before we went forward with depositions. And that's why it's not in the record.
Okay. All right. Anything else?
I just the final element is the due diligence aspect, Judge, and so I just wanted to outline what we've done. On March 4th, 6 days after the ruling on the first MSJ, plaintiff served discovery requests. Plaintiff waited for the ruling on the MSJ before serving these so that we could narrow the issues in our request. On April 17th, 2 weeks after the extension, defendants responded again they produced nothing, Judge. They produced plaintiff's own pay records, and there was no mention of an employment file. And then defendants they filed their summary judgment within this extension period that was granted to them by plaintiff. April 18th, we sent a discovery letter. Counsel says she could not confer on the discovery letter until after our MSJ response was due. This was the very first time she brought up okay. I
get it. I get it from here. Okay, so let me hear a response.
Your Honor, the timeline is not quite as plaintiff alleges that it is. So this case has been pending since October of 2023. The assault claim was brought at that time. It was actually brought in the federal action too. That's been pending was pending since 2022. So in October was when this case was filed. We filed our first motion for summary judgment as a matter of law on all claims in November of 2023. Plaintiff didn't say they needed any discovery. We had that hearing. The court made its ruling. Defendants filed their second motion for summary judgment April 8th of 2024. Yes, Mr. Havens is correct that they served discovery in March, but that discovery consists of questions like, and I'm reading from the interrogatories that were submitted to the court, identify all persons who made a complaint of harassment against Dr. DeMaio. Interrogatory number 8 to HTPN. For each individual who filed a charge of discrimination, identify that charge and details about it. Interrogatory number 10. Identify patients who complained about Dr. DeMaio. None of this discovery. None of the discovery had.
Can't even see me.
I'm sorry, I'm someone speaking.
There's someone talking here. Sorry.
None of this discovery had anything to do with course and scope of employment, ratification, or intentional infliction. So on April 9th, I contacted Mr. Havens' office and said, I'd like to set this for a hearing, offered dates. I heard nothing back. I heard no pushback. We need discovery, nothing. So we served our notice on April 10th, 33 days before the hearing. Plenty of time. Then 9 days after we served that hearing notice, and within 1 hour, here's what plaintiff does. At 4:21 p.m., I get the very first in the entire case request for depositions. Very first. And as the court noted, a lot of those deposition topics have nothing to do with course and scope and ratification. At 5:17 p.m., within the hour of that being served on me, they file their motion to continue. Then at 5:21, they file their third amended petition. So all of this is within an hour. That is not due diligence at all. They made no deposition requests before we filed our second motion for summary judgment. They did send an email that said, hey, we just think there are some general discovery issues. I wrote them back and said, what are your issues? Here's the time I have to talk about it. And they didn't respond. And the letter that was sent, which is also in the record, is just a broad, we don't like your discovery responses. Nothing specific, nothing to confer on. That's not due diligence either. None of the discovery asked for course and scope of employment. And the reason I think is very clear. These are matter of law issues. Addressing Mr. Haven's contest or contention that somehow he needs all of these depositions now, he didn't even ask for the declarants' depositions. The very people he's complaining about, he didn't even ask for their depositions. And the reason is this. There are two issues here. These are matter of law, Judge. The first is it within the course and scope of a thoracic surgeon's employment to allegedly sexually harass someone during an emergency patient situation? Question number two, is there a gap filler that's required here because there's no other way that this plaintiff could recover for emotional distress? Those are matter of law issues. The Mastech case says that they are. And to Mr. Haven's contention that these are fact issues, that's not what the Mastech case says. And Mastech is a Dallas Court of Appeals case on which we rely. In that case, what it says, and I'm reading from the case here, it talks about when an employee commits an assault, it is for the trier of fact to determine whether the employee ceased to act as an employee and acted instead upon his own responsibility. This is what the Court of Appeal says. That holding, however, followed our recognition of the predicate general rule ignored by the plaintiff in that case, who is taking the same position that Mr. Havens is taking that same position, that the employee's tortious conduct will fall within the course and scope. So this isn't a fact issue here. The court can decide course and scope. We've cited 14 cases, and that's just a sample of them, where courts routinely decide this as a matter of law, course and scope. It is not within the course and scope of a thoracic surgeon to sexually assault a nurse while they're in an emergency patient situation. As for the gap filler, Your Honor, you have already decided that the assault claim could go forward. Assault claims have mental anguish damages. I think this court is well aware that intentional infliction is a gap filler tort. If there's no other tort available, you get intentional infliction. But here the court's already ruled she has an assault claim, whether it proceeds or not, she has it. Therefore, that intentional infliction claim is barred as a matter of law. There's no fact issue here. There's no discovery to take on it. So there is no materiality issue here. They haven't exercised due diligence. There is no materiality. They didn't ask for depositions until the day they filed their motion for continuance. The court should grant the summary judgment.
Okay, so let me just say this. I've been doing this a long time, Ms. Waltner. I respect the approach you're taking. I do think it's a little more aggressive than I usually see, at least in my court. I do usually allow, having 2 summary judgments within the first few months that the case is actually on file is pretty unusual. I usually am going to allow the parties to engage in discovery before. I usually would do it before the first summary judgment, but I felt the first summary judgment, because it was mostly an issue of preemption, it wasn't necessarily needed. But I think in this situation, there is the need for some discovery. I do want to hear a little bit of merits argument, not a lot, but we will probably continue this hearing. So, Ms. Waltner, do you want to just kind of give your, and am I saying your name correctly? I'm sorry if I'm, how do you say
Yes,
your
Your
name?
Honor. It's Voltmer. Your Honor, this case has been set on your non-jury docket for July 2nd, I believe. The plaintiffs just paid a jury fee last week, but this case was set for trial originally in July. So to the extent that the plaintiffs are saying, we need more discovery, they've had plenty of time to do that based on the court setting of the trial date. But setting that aside, again, we have cited 14 cases.
Let me just say this. Mr. Havens, is that your name, Mr. Havens?
Yes, Judge.
Mr. Havens, I do agree with her when we set this for trial, it was probably a little bit aggressive. If somebody is paid a jury fee, that's not gonna work that week anyway. And so if you want a continuance of the summary judgment hearing, we're gonna need a continuance of the trial setting too. I think it's only fair to Ms. Volkmer. Would you
Yes, Judge,
rather?
we anticipated that, and we hadn't initially paid the jury fee, but we wanted to get that on file and make our jury demand, and we anticipated, and a counsel for defendants had brought up the need for a continuance and maybe a scheduling order.
I totally agree with that. When do you want to reset this to? Have you guys talked about it, the trial setting?
We have
have
not. Um,
Do you want to talk
But
about
I-
it now or?
yeah, I mean, we can talk about it now. I imagine either late 24 or early 25 for a jury trial.
Ms. Waltmer, how do you feel about that?
Early 2025.
Let's kind of look at the docket. I don't think this case would need a special setting, but I know that your doctor probably has a lot of surgeries and stuff scheduled, so I would be willing to especially set it if you want that, but I would want to know for sure that the date is good for all the parties. You want to have like, my thought would be maybe we reset the motion for, maybe set this for a scheduling conference next Monday, and you can talk with your doctor about whether or not he wants a special setting, and I can give you some dates that might work. Would that work for you, Ms. Waltmer?
Well, Your Honor, Dr. DeMaio is actually represented by Mr. Simon Whiting, who's also on this call. I don't
Oh, I'm so
represent him.
sorry. I'm so sorry, Mr. Whiting. I didn't realize that. I apologize. So, Mr. Whiting, what is your thoughts on that? We can't hear you. Mr. Whiting. I still can't hear you. Can anyone hear Mr. Havens? Can you hear him?
No, Judge.
You may want to check the sound on your computer. While you're doing that, what are you here for? Are you here for a hearing or something?
Yes, Your Honor, I'm here for a 10 o'clock hearing on a summary motion that has no summary judgment motion on file.
What? Okay. We don't have a 10 o'clock summary judgment hearing.
Okay,
Do you have you mean a scheduling conference?
it's the two partners versus MMR and Russell.
Mr. Whiting, keep working on your sound. Why don't you come on up and I'll try to find it, see what's going on. I apologize. I'm not sure what you're talking about.
I'm downstairs in trial on another case. They just let me up here so I can.
Yeah, no problem. Let me get you out of here as soon as you can. What's your cause number? Okay.
-2.
100, I'm sorry, say it again.
10083-2.
DC. Is that in my court? That isn't a cause number that we would have. Is the -2, that's not, are you sure that's not maybe in another county? Let me look. Can I just see your 1003-2? Two partners versus Russell.
Yes.
You have a hearing on June 24th at 1:30.
That's on the schedule. There was one second today, maybe you told it. You told me you would, but I never got a correspondence from them.
We got an agreed scheduling order on it
Yes.
on May 23rd. Let me just make sure it's not on here anymore. No, it's not on here. I'll go ahead and print it out and make sure we get that.
Okay, all right, thanks very much.
Right, you have a good day. It's good to see you again.
See you guys. All right, all right.
Mr. Whiting, is your sound working? You want to sign on with your phone, maybe? Mr. Whiting, do you want to sign on with your phone? Okay, guys, I'm going to put you guys into a breakout room with Mr. Whiting. Maybe he can figure out his sound issue. You guys talk about proposed dates for the trial, and then we'll let you back. Just come back into here.
Thanks, Judge.
And also talk about when you want to reset this for hearing as well. Mr. Whiting, we're putting you into a breakout room. Okay, guys. Anyone here on Lira versus Salami?
Yes, Your Honor.
Yes,
All right. Mr. Borstein, are you here? Is this case ready to prove up?
Yes, Your Honor.
All right. Let's go on the record on DC 21-10580, Lira versus Salami. Counsel, make your appearances.
Jessica Babawi for the plaintiff.
Jasmine Robinson for the defendant Harrison Salami.
Jason Borstein, the guardian ad litem for the minor.
I am Frank Lira.
Say your name again, sir.
Frank Lira.
Great. All
Yes, sir.
right. Let's go ahead and proceed.
Excuse me. Plaintiff calls Mr. Lira. May we proceed, Your Honor?
Mr. Lira, please raise your right hand. You swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
All right, you may proceed.
Mr. Lira, will you please state your full name for the record?
Frank Lira Jr.
And are you the parent or guardian of Destiny Lira?
I am the father.
Are you responsible for Destiny Lira's welfare?
Yes, ma'am.
Okay, do you understand that the other party involved in this accident had an insurance policy with Nationwide Insurance?
Yes.
And do you understand that Destiny's case, just Destiny's case, settled for $7,000?
Yes, ma'am.
And do you understand that if we had gone to trial, we could have been awarded a judgment that was more than that, less than that, or the same amount, and that's a risk that's associated with going to trial?
Yes, ma'am.
And do you agree that that amount in your mind is a fair settlement for the